This lecture is on the negligence aspects of products liability. Now you recall that there are three theories for recovering for injuries caused by a defective product. Negligence of someone in the commercial chain of distribution, strict liability, and warranty. And this lecture deals with negligence. Now, if you're suing someone for negligence in a products liability setting, please keep in mind that in each of these three ways in which you sue people for harm caused by a defective product, you're looking at different bases for the liability. In the case of negligence, you're saying somebody in the chain acted, their conduct was negligent conduct. So the analysis here, negligence, is aimed at the conduct. Secondly, if you're looking at strict liability, you're talking about whether or not the product is defective. And your analysis is aimed at the product. Is it defective or not? And did the defect cause injury? In the case of warranty, you're looking at promises that were made. And did someone make a promise, either expressly make the promise, or the law implies that they made the promise? And if they have made a promise, was the promise breached? And that's your breach of warranty. So here we're talking about negligence, so we're talking about conduct of people. Now the negligence analysis here is just like analysis is for any other negligence problem, no real difference. The elements are the same elements. They're on the board here. You know what they are. The elements are duty and breach, actual cause, proximate cause, and on the next board, damages and defenses. No difference than a regular one. There's certain things I want to point out to you to be sure to deal with, though, as you go through. First, the duty. The duty is owed by everybody in the commercial chain of distribution, and it's owed to all foreseeable plaintiffs. Now, the people in the commercial chain of distribution include people like the retailer, the manufacturer, the designer might be a separate person from the manufacturer, the component manufacturers. All these people, they all owe a duty of due care to all foreseeable plaintiffs. But each of these people is involved in a slightly different kind of activity. And so the way in which those people might breach the duty of due care is kind of unique to the activity they're involved in. See, that will come up on the exam. So for example, a retailer. We had a problem that you're looking at today in which there was a lawnmower that you see here, this carefully drawn, artistically a beautiful lawnmower. I must ask those of you who are watching this not to try to sell my paintings here separately. But there was a lawnmower, and the lawnmower had a foot switch, had a switch right here for turning it off. And when this lawnmower started vibrating, in the problem you recall, the person put their foot down here to cut off the switch, and their foot got injured. Now, we're talking about negligence, and this obviously is a designer. Whoever designed it shouldn't have put the switch, the foot switch way down there. You don't need a foot switch, put it up here. And this is because there are reasonable alternatives, and if you use something like the risk utility analysis in your negligence analysis, that is a balancing test, you would say in the risk utility analysis that it is risky. You explain why it's risky to put the foot switch down here, and that it is inexpensive and easy to put it up here, and they should have done it. To not do so creates unreasonable risk of harm, and that's your breach of duty. And so a designer, in this case, designed this negligently. Now keep in mind that if you design something negligently so that it creates unreasonable risk, that when you now do a strict liability analysis, that's going to be a defective product, and strict liability is going to apply to that. So it's interesting that what turns out to be a design defect because it was negligent, or even a warning defect, you should have warned because it was easy to do and didn't do it, and the person failed to do that, you can end up with strict liability because that failure to warn or the failure to design it safely makes the product defective. And so when you look at the product under strict liability, you will say the product is defective and strict liability applies. So this conduct gets used twice. So here, this lawnmower is an example of a negligent design. One of the other problems you're looking at today, by the way, with this lawnmower, obviously it was a negligent design. The instructions were inadequate. You recall from the problem it said keep blade wet, but really it said keep blade wet to avoid degradation of the blade. Well, really what happens if you don't keep the blade wet, the blade will shatter and come apart and might kill you. And so the instructions were inadequate, the warnings were inadequate, and it's easy to do these, creates unreasonable risk not to do it, so this was negligent conduct. And this same conduct, by the way, is also going to make the lawnmower a defective lawnmower when you do the strict liability analysis. But right now, negligent design, negligent instructions, negligent warnings. Over here in the allergy problem that you read for today, in the allergy problem, the person took the allergy pills, losing their eyesight. The doctor knew about this, did not warn, and so this was negligent not to warn, and also probably the product was defective and without those warnings, and strict liability applies. The retailer, let's look at so the designer can be negligent. Obviously, the retailer can be negligent. You can be negligent by failure to warn. The retailer, let's talk about the retailer for a minute. The retailer, the way the retailer can be negligent really is only a few things that the retailer does. The retailer buys them from somebody else and sells them to you. And if the retailer is using a shoddy supplier, and they know this is a shoddy supplier because other customers have complained, okay, then the retailer may be acting negligently to continue to use this supplier when they know that people are complaining about the product being dangerous. So that's one way that the retailer can be negligent, is by using a shoddy supplier. Another way is that the retailer normally does not have a duty to inspect the goods. Safeway doesn't have to inspect everything that comes into the Safeway store. But certain kinds of, that's the majority rule, that's a general rule. But certain kinds of goods, there's a minority rule that says for these kinds of goods, the retailer may have a duty to inspect. If the retailer is selling you complex machinery and you don't have the skill to inspect it, an airplane, the retailer is selling you an airplane, they have a duty to make at least a cursory inspection of the safety features. Automobiles, motorcycles, this is fairly complex machinery, and the retailer has the skills to at least check the safety items. So there's a minority of jurisdictions that say in those cases the retailer does have a duty to inspect, but ordinarily the retailer does not have a duty to inspect. This lawnmower, for example, was purchased in a box at a store, and so of course the retailer didn't even have an opportunity to inspect. No duty to inspect that. So the retailer can be negligent by, in those minority of jurisdictions, failure to inspect complex machinery. In general, no duty to inspect, but a failure to continuing to use shoddy suppliers when you know that that's happening. So the retailer needs a reason to know. In order for the retailer to be negligent, they have to have a reason to know the product may be defective, or they have to inspect and discover that reason. Manufacturer can be negligent. Manufacturer can be negligent in any of the activities that the manufacturer is engaged in. These are some of the typical activities. The manufacturers design, they manufacture, they inspect, they test, they ship, they instruct, they warn. In any of those areas, in everything the manufacturer does, they owe a duty of due care to the foreseeable plaintiff. And so if you get them doing any of these manufacturing things, they have to do it with due care, and if they don't, that's a breach of duty to the foreseeable plaintiffs. In negligence, everybody in the commercial chain owes this duty of due care to the foreseeable plaintiff. Now, it might be worth mentioning on your bar exam answers that no privity is required and that we don't have to have inherently dangerous products in order to not require privity. This comes from some old cases that they're old enough now that I'm surprised people continue to cite them. But the privity requirement comes from an old case. This is an 1842 case. And this is Winterbottom versus Wright. And it's an old British case, happened in England. And this person was a mail carrier. And he rode a mail truck, drawn horse carry mail truck, delivering mail. And someone else, a third party, called him T, third party, had a contract with the post office to maintain this wagon that he was, what do you call it, they were delivering the mail in. And the wagon was defective because the person didn't maintain it properly, and it broke and the driver was injured. Now the driver sued the company that was supposed to repair the coach for the post office. And the court at that time in 1842 said, well, this person repairing the coach for the post office had a contract duty to repair it. There was no tort obligation. And that they didn't have any tort obligations. All they had was the contract obligation to the post office. They never even had a contract obligation with the injured party. So the injured party got nothing in that old case. And you can see that's kind of ridiculous. We wouldn't do that today. The person who was maintaining that coach would owe a duty to the coach driver, the ultimate coach driver, not just the person who hired him to maintain it. And so that change happened much later. That happened about 74 years later. And it's, so that, I guess it was in 1916. Yeah, it was. It was in 1916. Along came the Buick McPherson versus Buick. And McPherson versus Buick says, oh, no, that we're not going to do things that way anymore. In McPherson versus Buick, the person was driving a car, obviously a Buick car, that they had bought from the dealer. And the car had wooden spokes on the wheels, and as they were driving the car, the spokes broke, the wheels collapsed, and there was an accident, and the driver was injured. And the driver now bought the car from the dealer, and when the driver sued Buick Company, normally you run into that same problem that you had in Winterbottom versus Wright, namely that the driver of the car didn't have any contract privity with the manufacturer of the car. Well, that's when the law got changed. It took a long time. The court said, forget it, that the car manufacturer can be sued even though there was no contract with them, that there's a tort duty. The court just created it right then. Said there's a tort duty to, if you're going to manufacture this car, you got to do it with due care, and you owe that duty of due care to the people who are expected to use the car. And that's when the law changed. And because of these two cases, Winterbottom versus Wright in 1842 and McPherson versus Buick, this is when the privity came in, and this is when the privity went away. But when the privity went away, the court, even during this period from 1842 to 1916, when you couldn't recover without the privity, the court made a bunch of exceptions. They said, well, there's certain things where you can sue the real maker even though you don't have a contract with them. They say in cases of inherently dangerous products in food, that you can sue people higher up on the chain even though you didn't deal directly with them if it's an inherently dangerous product. Things like defective guns. There was a dynamite stick where the fuse on the dynamite was shorter than it should have been. The person lit the dynamite and it blew up early and they got hurt. Well, dynamite's an inherently dangerous product, and the court said, you don't have to just sue the retailer you bought the dynamite from. You can sue it from the manufacturer of the dynamite. So inherently dangerous products came along first and said, you don't need privity in these cases. And then after 75 years or so, the court said, you don't need privity at all, that whoever is making this product, that they owe a duty to the ultimate user because it's foreseeable that's who's going to get hurt if it's defective. So the summary of duty is that the duty is owed by everybody in this manufacturing process, retailer, manufacturer, designer, component part, and each of them is doing a different thing, and they can be negligent in what they're doing. They owe that duty to all foreseeable plaintiffs. No privity is required like it was in Winterbottom versus Wright, and you don't have to have inherently dangerous products anymore like you did in McPherson versus Beard up until then. So that takes care of the duty owed. Now the breach of duty on this board, for products liability, you determine the breach of duty exactly the same way you do for other negligence problems. There's negligence per se. So if you're making a bottle of something, and on the bottle the law says you got to put a warning on the outside, skull and crossbones or whatever the warning is nowadays, and you don't do it, that's a breach of, that's violation of a criminal statute, assuming the statute is criminal. That's negligence per se. But normally the negligence per se involves things like driving cars and violating speed limits and running through stop signs and that sort of thing. But in a products liability situation, you'd have to have a situation where there was a criminal statute that addressed the manufacturer, said, manufacturer, you must do certain things or that's going to be a crime. And so you're not going to find that very often. So this isn't likely to happen in a products liability case. Violation of the standards of a profession or skill. The way this comes up is when a manufacturer of drugs, for example, has given the drugs to a doctor, a hospital, or someone, or given to a pharmacy, and the doctor is what's called the learned intermediary. And the drug companies inform the doctors about all the things that can go wrong, and the learned intermediary is expected to pass on the critical information to the patient. And if the learned intermediary fails to do that, that's not the drug company's fault, that's the doctor's fault. And so in the case of the eye problem that we had, the allergy problem where the person was going blind because of the allergies that we just talked about a minute ago, in that case the doctor failed to tell her that one of the side effects of this allergy pill is that for very few people it causes blindness. And that probably violates the standards of his profession not to give her informed consent about the use of that drug. Now, the doc said, well, this is the safest, that this is the best drug for your kind of allergy. Well, that may be, and it may be that this drug has an unavoidable danger to it. It's unavoidably dangerous. Some things are, because they have side effects that you can't avoid. And that's okay if the benefits is high enough for whatever the side effect is, but you still got to notify people. You got to warn people. And this may be the best medicine for this person's allergy, but the doctor did not warn that blindness was a part of it. And so that's a failure to warn, that's negligence. It also probably made the product defective. It might also breach warranty, but it certainly is negligent conduct, partly because the doctor has violated the standards of a profession or skill. Balancing test, the risk utility. When people have not been warned, it's usually very easy to warn, and if it's very difficult or dangerous not to warn them, then you can use the balancing test to say that it was a breach of duty not to warn. Now, in the case of this balancing test, things like allergies, one of the interesting things about allergies is that if the allergen only is in a place, if a person is allergic to something, you don't normally have to warn them every time that a few people are allergic to this. But if this allergen is in some place where you wouldn't expect it, that the seller put it there, or for some reason you wouldn't have expected it to be there, then you got to warn people about the allergies. Otherwise, you presume that people know what they're allergic to, and you don't have to do that if it's a natural consequence of that particular compound. Also, when there are very few people who have this kind of an allergy, if there's 1 in 10 million people have it, do you still have to put the warning on there? Well, probably not. But you have to let people know the contents that are there, and you let them know the contents and what the consequences of this content are. This compound, this drug, this whatever it is, has got so-and-so in it, and it may cause so-and-so. You got to tell them those two things. but you don't have to tell them anything if that allergen normally appears there. And if there are very few people who ever have this effect, do you still have to tell 1 in a billion people? And the answer is probably no. But where do you reach the point where you don't have to warn anymore? It's a risk utility analysis, and you just say something about when it depends. It actually turns on how serious it is. If there's 1 in a billion people who are going to die from taking this, you probably ought to tell them. If it's 1 in a billion people who's going to have a bad night's sleep because of this, you don't have to tell them. And so it depends on how many people will be affected by it, how serious the effect is. And that's what you do about those cases. And the res ipsa, res ipsa is used a lot in manufacturing defects. It's used a lot in manufacturing defects because if you buy a car and the wheel comes off that car and you want to sue the manufacturer, well, you don't know exactly what happened at the assembly line, but you can say that cars just don't come off the assembly line with some of the bolts missing off the wheel unless somebody up there was negligent. And that somebody was one of the employees of the factory, and so under respondeat superior you can sue the factory. So in manufacturing defects, you will find that this is a very common device that's used for manufacturing defects. This is, but again, if you're talking about a defective product, then you're looking to see, if we're talking about negligence, we're saying the wheel came off, somebody was probably negligent. If you're talking about a defective product, we'll do this more when we cover our lecture on strict liability, but if you're asking, was the product defective? And the answer here, of course, is going to be yes, it was defective because, you know, it doesn't meet the reasonable expectations of safety of the consumer because the wheel came off while you're driving it. But, so it is defective, a manufacturing defect, because the other cars came off the assembly line, don't have wheels that come off. So you have a manufacturing defect because the wheel came off, but you might have a design defect. Now, if the wheel came off because they didn't put the bolts on, that's not a design defect. But if the wheel comes off because it wasn't designed properly, that's a design defect. And when you try to prove that something is designed effectively, you will generally end up using the risk utility analysis. And so for design defects, you'll use this, and for manufacturing defects, you'll end up using this. Now this comes up in strict liability, but I'm just pointing this out because what's very important here is that in these strict liability cases, even though we're talking negligence right now, you actually end up doing a negligence analysis to decide that the design was a defective design, and therefore you have a defective product. You use you might use something like res ipsa to show that there was a manufacturing defect, and now you've got strict liability. So the point here is that you might use the balancing test and res ipsa both in negligence to show breach of duty, but these are also used in design defects and manufacturing defects when you're doing the strict liability part of the analysis. That takes care of breach of duty, ordinary, nothing special about it. Just be careful and cover everything. Actual cause, a couple of things here on actual cause I want to call to your attention. We have this thing called general actual cause and special actual cause. Now, general and special actual cause is language that's just beginning to get used now. It's used in the third restatement, and the third restatement is used a lot in products liability now. We'll talk about that in strict liability. But suppose you have a medical situation where this person took some medicine and they got sick, and they're saying the drug was defective. Well, there are other things that can cause this kind of illness besides the drug. So what caused it, the drug or this or something else? And so if you sue the company, they're going to say that something else caused it when you're saying the drug caused it. Well, how do you decide? Well, suppose the drug increases the likelihood that this will happen to you. It's not guaranteed, but if you take this drug, you're 5 times DES. You take DES and you're 10 times more likely for your children to have birth defects than if they didn't. But birth defects happen for other reasons besides that. the Agent Orange that was used in Vietnam, the sickness that people, the cancers that people got from Agent Orange. Well, people get cancers for all kinds of reasons. So how do you establish that Agent Orange was the cause of it? And so in those situations, we use what's called epidemiological data, and if you can show that the exposure to whatever this is, to the drug DES, to the Agent Orange, if you show this exposure significantly increased the probability that the person got the disease from Agent Orange or from DES. In the case of DES, it was easy, like something like 10 times more likely to have birth defects. And so if you have substantially increased it, then that still doesn't prove that this particular person got their cancer from Agent Orange, or this particular birth defect is caused by DES. But if the likelihood of it happening is increased enough based on this epidemiological data, then you can use that for a specific cause. The jury can conclude, if it wants to, that more likely than not, this drug or whatever it was caused this particular person their illness. So you can, but for a substantial factor. Here, don't forget one other factor that comes up here on actual cause, that if the item was substantially changed, the lawnmower has been repaired in some major way or something, that if the item doesn't get to the consumer substantially unchanged, then the manufacturer would not be liable. But otherwise they will be. So specific cause is that you can, if it got there substantially unchanged, you can use, that satisfies, and but for the damage, this wouldn't have happened. That's specific, but for the drug or whatever. In other words, you can't really prove the but-for test with this epidemiological data. But if it's strong enough, courts are permit the jury to find that. So the jury can find specific cause if the epidemiological data is strong enough. If the epidemiological data is not strong enough, they will not be able to find specific cause. Proximate cause, under proximate cause, same old stuff for negligence. The duty in direct causation cases, the cause must not be too remote, from the conduct of the defendant, from the negligence of the defendant. And in the indirect causation, you look for intervening events. And don't forget that reckless intervening events are not foreseeable. They will terminate liability. A typical example of reckless intervention would be where the manufacturer makes a lawnmower, makes a car, whatever it is. They send it out to the dealer sells it to the customer, but the manufacturer says to the dealer, you know, we screwed up, please fix the so-and-so before you sell it. So now the dealer has actual knowledge that the steering wheel is defective, that the brakes are defective, something important like that. And the dealer has actual knowledge and they don't fix it. That is so reckless that that intervening conduct terminates the manufacturer's liability. But it takes something like that to do it. Actual cause, proximate cause. This brings us to damages. As usual for negligence cases, the damages must be actual, causal, foreseeable, unavoidable. Nothing all that special about this. Please keep in mind that just as in regular negligence cases, that you cannot recover pure economic loss. So someone was negligent, they manufactured the truck defectively, and because of the defect, I can't use it for a week, and so I want to sue for their negligence. That's pure economic loss? No. You go to the UCC and do what you can under the UCC for that. You sue the person that it's a pure economic loss you cannot recover. If the truck was wrecked and because of the defect, if the truck injured someone else and the truck was wrecked, and now you sue, the injuries to the someone else, of course, the someone else can sue for themselves, they'll get theirs. When if you got personally injured driving the truck that was defective, you can sue. But the truck itself, do you get the truck itself replaced? And the answer to that is the majority of jurisdictions, no. You get your personal injury, you get property damage, but the truck itself, you have to go to the UCC to get those damages. The defenses are the same, the usual defenses. Statute of limitations, which is never tested. Comparative negligence is tested. Does apply to negligence essentially all states now. So you don't have to talk about the several kinds of comparative negligence. Just assume it's pure comparative negligence and say that the defendant's recovery is reduced by the degree of his or her own negligence. Assumption of the risk applies to negligence, of course, and there are some immunities. The immunities have never been tested, but these are family immunities, and we'll talk about those in regular negligence. So that's a summary of how you handle a negligence problem in strict liability. The summary is just the way you would expect, that you establish that the defendant owed a duty of due care to all foreseeable plaintiffs. That's a rule of law. And whatever this particular commercial person is doing, retailing, manufacturing, designing, and so forth, they have to do that with due care. You can mention that no privity is required. You don't have to have inherently dangerous products anymore. So you establish the duty, breach of duty, usual methods, negligence per se, violation of standards of professional skill, balancing test, or res ipsa. That when you later do a strict liability analysis, that the risk utility analysis is generally used to establish whether or not there was a design defect. And if there is a design defect, there's going to be strict liability for that. And when you're looking at manufacturing defects, it's most convenient to use res ipsa for that. And again, if you find res ipsa, it's going to end up being a defective product, and strict liability will apply. Actual cause, the usual rules of actual causation. The main addition here is that in the cases of epidemiological data, if it's strong enough, you can infer specific cause. If it's not, you cannot. Proximate causation, direct if the injury is if the product is designed negligently or manufactured negligently, and someone is injured 5 steps away. In other words, the product designed negligently caused A, and A caused B, and B caused C and D, and so forth. At some point, you're going to stop, even if they're not intervening events. You just got to stop. You can't. The public policy doesn't let you go out there forever, and so it can't be too remote in direct causation. And in indirect causation cases, you're looking for intervening events that might have terminated liability. In products liability cases, the place where that is most likely to occur are cases where the manufacturer has sent it to the dealer, and the dealer knew about this defect. Either the manufacturer told them or some other customer told them, and they didn't fix it. That would terminate liability. After proximate cause, damages, usual stuff, but you cannot get pure economic harm, and the defenses. That's what you do about negligence in products liability cases, and that is the end of this lecture.